Hello and welcome to The Talk with Tariro. Today on the program, we are still continuing with our discussion looking at issues of rape, sexual violence during this particular period where we have COVID-19 lockdown restrictions being prevalent. How are we dealing with that? And on the program today, we are looking at accessing the justice system, especially during this period when you have experienced rape, gender-based violence, sexual gender-based violence. How easy is it? And I have those we call the learned friends on the program today. That's our Zimbabwe Lawyers, Women Lawyers Association, and I have the executive director, that's Abigail Machai. Abi, welcome to the talk.
Thank you, Tari.
Yes, I want to find out from you. We are in the COVID period where sometimes movements are restricted. Yes, we know they are loosening, but would want even to start from the period of March when we had tight lockdowns and then people needing to access justice system, accessing even the courts, accessing your services. How has been the situation?
Thank you for that question, Terry. So we note that the COVID environment is a very difficult environment for all stakeholders and all of us, and particularly for survivors of violence. So when we were initially on the total lockdown, that was a very, very difficult period, because what you would find is that survivors were locked down and staying in homes with potential perpetrators or perpetrators themselves, and failing to then be able to move around to access services. So it was a real challenge. And we noted in that period that much as there were many cases of violence, but there were very few people who managed to access services because of the total lockdown.
Yes. And when you're looking at the trends that you normally witnessed before the lockdown, before COVID came in, and what then prevailed during COVID, what's the comparison there?
So before COVID, you find that the women who would report their cases, we had high numbers of reports that were made, more due to the ability to move around from one stakeholder to the other and access the services. But when we got into total lockdown, we saw a significant reduction in the numbers of reported cases, or even cases of women just accessing the services. I'll tell you, for instance, from our perspective as well, you would find that we had a reduction of perhaps almost 50% of the women that we normally assist on a good day. And we attributed that to the difficulty in just being able to move around to access the services. And the number slightly then increased as the relaxation of the lockdown measures were put in place. Yes.
So let's look at the whole issue holistically. I've been raped, or I've been beaten up at home. I'm contacting you as Zimbabwe Women Lawyers Association. What happens there?
So when violence occurs, we encourage, firstly, that the survivor should not blame themselves. And this is important because once you blame yourself, it inhibits your ability to make a report or to seek service. So the starting point is to understand that you didn't cause the violence. The problem is with the perpetrator. And once that happens and the survivor has accepted that they have the fault is not on their part, it would then mean reaching out for service. One of the difficulties is that most cases are reported late. And so when they're reported late, you will find that the evidence that could be gathered is lost. So you've been raped today, the report is made a year down the line. Certainly evidence that could have been found at the time of occurrence is then lost. So the other thing we encourage is timeous reporting. by survivors. And this is important because when the case is then prosecuted in the courts, the evidence is what will make the case strong. And so for as long as there was late reporting and perhaps there isn't sufficient evidence, those are the cases that worry all of us when we see that the perpetrator has been let go because perhaps there was insufficient evidence.
And when you're talking about evidence, where you're saying timeous reporting, we want the evidence to be there. What is the evidence that is admissible in court?
So when we look at evidence, each case is based on its own facts. That's, I think, one of the overarching principles. So depending on where the violence occurs, for some people, for instance, the violence might occur and their witnesses have been raped in the home and there are other people that were there when the incident happened. But for some people, there might be no witnesses. It was the two of us having gone on a date and then, you have been raped. So there will be those variances depending on the facts of the case. But broadly speaking, you are looking at evidence that is gathered from witnesses who saw the incident or perhaps witnesses that you told about, you spoke to after the incident happened. We are looking at any physical evidence that remains on your clothing. For example, you might have torn clothing. If you get medical help immediately, the rape kits will pick up semen, for example. Those are the different forms of evidence that are collected from the scene, as well as gathered from the witnesses if they are present. And so those are the types of evidence that would then be admitted within the court of law. I think one of the major challenges that occurs with survivors is at times without knowing the law. You are raped today, you bend the clothes because you don't want them to remind you of the incident. You wash up, you don't report. So in that process, unknowingly, you are destroying evidence that could help support the case, but it's not there anymore. Some people have videos, for example. These days with technology, people, record, but you delete those and things that could help support the case are lost in the process, perhaps because the survivor is not knowledgeable. So that's one of the challenges that is there when we talk about evidence. Yes.
We'll continue with this discussion after this break, where we are looking at seeking justice when I've been abused, when sexual gender-based violence has been perpetrated on me during this period where we have COVID-19 amongst ourselves. Welcome back. We continue with our discussion. And before we went for the break, Abby was explaining to us the importance of having admissible evidence. Abby, you still wanted to continue in terms of how important it is to have all the necessary evidence for us to then have the perpetrator eventually persecuted, sentenced, and all.
Yes. So to continue with evidence, it is important. Again, I can't stress as much around ensuring that the survivor accesses the rightful duty bearers on time. What we've noted from experience is that when violence occurs, you find that at times the reports, people spend time within the family. People spend time going to access their religious leaders, going to access various social networks that are there. But in that, time is being lost as we go from one person to the other. You also find the re-victimization of the survivor, because at every interval you are telling the story one more time. You've gone Kwambuya, you say it again. You go Kwamfundisi, you say it again. And eventually, when you then access the health officials, for instance, some evidence is already lost out. When you then make the police report, for example, perhaps the witnesses have moved, perhaps the evidence is no longer in place. So these are some of the things that mitigate against the case. And we stress all the time that, yes, it's important to talk about it within the family, but it is equally important to go to the rightful duty bearers on time so that they gather the evidence, even if the case is prosecuted much later. But as long as the evidence has been gathered and it's intact, it will enable the prosecution of the case successfully and the conviction of the perpetrator. Yes.
What I want to also find out is coming to you, and then we've got the courts on the other side. Has there been any agency, that other side, in terms of making sure that these cases are actually dealt with in a timeous manner, the same way that you are saying we need to gather all this information in a timely manner as well? Because for me, if I've been violated and daily I'm seeing the person who has abused me walking around in my community, coming, threatening me, it becomes uncomfortable to deal with. Yeah.
So yes, there is agency in terms of the courts themselves to deliver justice on time. It's one of the objectives of many of the justice institutions. And you will find that there are set guidelines as to how long, for instance, a rape trial must take, set timelines, set processes that enable the speedy resolution of the case. I think a lot of the times you will find that time is lost perhaps in the investigation bit, which is done by the police, because the police would then have to gather as much evidence as possible to then present the docket to the prosecution. So I think at that level, you'll find that time is also lost in the case itself. But I think also important to say is that the issue about seeing the perpetrator walking around is around the conversation of the right to bail. And I think it's also important to talk about, because the survivor has rights in the same way this perpetrator has rights. At the point of appearing in court, you are still innocent until proven guilty. So much as the survivor is saying this is the person who has committed this offense, that person is only guilty when the court has made that determination. So in that regard, you will find that when they appear in court for the first time, they will make an application for bail. I want to be able to come and answer to this case from my home. And it is a right that any perpetrator or any person has, because you are innocent until you are proven otherwise. So it's something that presents a lot of challenges for survivors, particularly if you're staying within the same locality, or perhaps even at times within the same household, for instance. And it is important for the survivor to always provide evidence of interference, for instance, by the perpetrator when they are on bail. That evidence should be given to the prosecutor. Because whilst this perpetrator has a right to bail, they are not allowed to interfere with you or to threaten you, for example. They are not allowed to threaten the witnesses. So that evidence can only come from the survivor to the court to say, these are the challenges that I am succumbing to. Yes.
Yeah, so from what you're explaining, yes, the perpetrator has rights. Me as a person that has been abused, I also have rights. So the way I'm looking at it, it's important that as a person, I do understand also how the courts then work. But when I'm coming to you as women lawyers, I'm saying you are representing me as a person. When I come to you as an institution, how do you make me comfortable to be able to deal even with the stigma that's attached to rape, stigma attached to SGBV? Often we struggle even to talk about those issues.
Yes, so certainly what we do is we start by providing legal advice, where we explain what the law says in regards to the offense. We talk about these rights that you have as a survivor, in the same way the rights of the perpetrator. We also talk to your family members, or your support system, because you find that they also play a key role in supporting you as the case goes through court. for as long as you are not getting support, at times it even affects your desire to continue with the cases. We've seen cases where people withdraw the cases simply because perhaps the family has said, no, let's resolve it internally. It doesn't need to go to the court, or the perpetrator has offered to marry. Those are examples of some of the cases we come across. So you find that the support system is very key to support the survivor as she navigates the justice system. Part of what we also do is legal empowerment, where we walk you through what is going to happen in court. You are going in court, you can imagine, Tari, you are being asked about a sexual incident where you didn't give consent in a public court. And you are supposed to detail it.
Exactly.
It went on like this. Did I scream? What happened? You're supposed to give those intimate details. And it's very difficult. And so we prepare you to say these are the kinds of questions that you'll be asked.
Well, we will continue with this very interesting discussion after the break. Welcome back. We continue with our discussion after the break. We heard from Abi, if I'm going to court in a criminal case, the prosecutor is my lawyer. And my question to you, Abi, what if I don't have confidence in them? I want a lawyer. I want a lawyer representing me the same way this other person has got a lawyer. It's not possible.
So it is possible, but what is important is to say that the first step is to get that case through the state-provided prosecutor. There are options where you seek for what is termed private prosecution. If you remember, for instance, the Kereke rape case some time back, where they sought private prosecution to say that this matter has not been prosecuted to the best in our view, or has been declined, prosecution has been declined, so I want to pursue it as an individual. So there are processes that you go through, and you make certain applications for that.
I also want to find out about minors when they've been raped. We know there's talk of victim-friendly courts and all. Could you explain that process so that at least people do understand? Because the court process on its own, it's something that's scary to any ordinary person. Just going rotten rogo. It's not something that anyone is comfortable with. So sometimes just going in there, you lose your confidence. In the end, a person might actually be acquitted because of how I've presented it as somebody who has been abused as a survivor.
Yes, so the victim-friendly system starts off from the police, where you find the victim-friendly unit, a specialized unit in the police system that deals with SGBV cases. And so that's the starting point when we talk about the victim-friendly system. And then from the victim-friendly unit in the police, we also have the victim-friendly court, a specialized court that is meant to deal with matters of such sensitivity like SGBV. In the example that you've given, for instance, for minors, you will find those are cases that will go to the victim-friendly court. But in principle, when you look at the law that supports that, the victim-friendly court is meant to provide support to any person, because you can be an adult and you are unable to talk about the rape that has occurred by your father-in-law in a public court. So you want it to be in camera, for example. You want it to be you and the perpetrator not in the same space. Those are the kinds of things that happen in the victim-friendly court. So ideally, when we look at the law, it's supposed to provide support to any person who is unable to have their matter prosecuted in the normal way, where perhaps it's open court and you are explaining what has happened to you in such detail. So the victim-friendly court will, for instance, in the case of minors, they will try as much as possible to make the process simple. So it's not hard and fast as what would happen ordinarily, to try and make the child comfortable to explain. They will use dolls, for example, visual aids to help the child express the violation that has occurred. You know that many a times in the homes, we don't describe, for instance, anatomy in the way that it's known.
Yeah.
So there are always these names that we give within the home, teaching the child that, okay, this is called this. So when the child is trying to describe that in court, because at the end of the day, if it's sexual violence, you're trying to prove that there was penetration, and there was no consent, and you are trying to describe the anatomy of the man penetrating the woman. So you can imagine a child trying to explain that. And there's all sorts of language that we use at home. So the victim-friendly court tries to enable a conducive environment for the child to be able to explain the violence that would have occurred. So that would be the victim-friendly court. Ultimately, we should get at the end the conviction of the perpetrator if there is evidence that is sufficient, or the acquittal of the perpetrator if there is no sufficient evidence.
And I know when it comes to the issue of the acquittal, when it comes to the issue of the sentence, people always are not satisfied, especially from the survivor side. How does the law address that? Where someone is said to be getting 5 years, 3 years because of the evidence that was submitted, maybe enlighten us so that we get to know how important to make sure that we present all the evidence that will match the sentence.
Yes. So when we talk about sentence, certainly many a times you find that people are not satisfied. And that's very true, Tar. Particularly the survivors, they'll feel that perhaps the court was lenient. Perhaps the court didn't take into account everything. And, you know, people would want someone to be hung if possible. But I think in terms of just understanding the sentencing, you will find there are guidelines and there are laws that prescribe how the sentences are treated based per the offense that is given. So when we talk of SGBV, it's an array of different offenses. For example, you will have indecent assault in there, you will have sex with a minor, you will have rape. So because of those different offenses, they carry different sentences. You can have a rape case that has happened in Harare, where someone has used force, for example. Then you have another rape case that has happened where there was no force. You can have a rape case, for example, where it's someone of in a higher position, like your boss, your father. Those are things that are called aggravatory issues in a rape case. So once there are aggravatory issues, the sentence will also increase. So which is why you find in one rape case, perhaps they were given 5 years, in another, this one was given 10 years. The circumstances would vary depending on the aggravatory circumstances that are there. And I think for the survivors, it's important to be able, firstly, to know these issues and be able to present them to the perpetrator. At times when survivors, we see when survivors describe what happens, or even when they report the case to the police, they'll just say, I was raped. But when we are in the court case, things that aggravate, for instance, are, for example, how many times were you raped? So it's calling on the survivor to say, he raped me 3 times. That's different from a case where I've been raped once. He didn't use protection, for example, and there's likelihood of transmission of sexually transmitted diseases, the exposure itself. Those are things that aggravate. Incidents like I then fell pregnant, for example. Some are drugged. These days, people go out, you are drugged. Those are the different circumstances that surround the case that have an impact on the sentence itself.
In 10 seconds, how do people contact you?
So we are found on the different virtual platforms these days, given the issues of COVID. But I would want to give out our toll-free number where people can phone. It's free. And people can phone and get in touch with us. Our toll-free number is 0808 0131. I'll just say that again, 080 80131. Or we are also found on Facebook, Zim Women Lawyers, and our email address is zwala@zwala www.law.co.zw.
Well, that's all we had for you on the program. We will definitely make sure that we do invite the lawyers again on the program. We still need to unpack more of these issues. I'm sure you'll agree with me. We've just scratched the surface. Until next week, it's goodbye.